Good morning, everyone. My name is Dr. Patrick Viscuso. I'm one of the associate directors at the Information Security Oversight Office. Our office exercises controlled unclassified information executive agent responsibilities for the executive branch. And we are very excited to have you all here today to hear about the CUI program. The CUI program is a significant reform, security and regulatory reform for the executive branch. It will have a large effect, not only in the executive branch, but for our non-federal stakeholders. Today's briefing will be presented by one of our leads for oversight and implementation, Devin Casey. I also want to acknowledge our other lead, Mark Riddle, who is in the audience. And Devin will be presenting an overview of the entire program and will be open for questions at the conclusion of his presentation. So without further ado, I'd like to introduce Devin Casey.
Oh, don't applaud till the end. See if you like the program first. So as Pat said, I'm Devin Casey. I work in the Oversight and Implementation branch for ISOO on the CUI program. We also do a lot of outreach, so I like to think of it as kind of our third name, Oversight, Implementation, and Outreach. Today we're going to go over a briefing of the CUI, the Controlled Unclassified Information Program. It's an information security reform for the United States government that addresses how the government protects and controls unclassified information. We'll start off with a little overview of what the current practice is and why we need a reform, how the reform addresses those issues of the current practice, our implementing directive, the 32 CFR, Part 2002, which defines safeguarding for controlled unclassified information for the government. We'll also go over our approach to the contractor environment, some technical standards, phased implementation, the order and timeline that agencies should use to implement the CUI program. It's not a light switch program. It'll be implemented over the course of a few years. And then kind of the second half of the briefing, we'll dive into what those safeguarding requirements in the 32 CFR, our implementing directive, are. What do we mean by destruction and electronic safeguarding? Kind of the nitty-gritty of the program. And we'll end on some next steps, what we're doing and what we expect from you moving forward. So the government already protects unclassified information. The issue wasn't that it protects it, it was the effectiveness of the protection and the disparate programs it uses to protect it. So we have an existing body of laws, regulations, and government-wide policies that require agencies to protect information, but they weren't too specific on how. So every agency exercised their authority to define protect at their agency. Now, of course, some agencies define protect differently than others. The intelligence community agencies and law enforcement agencies have a different feel of the word protect than the non-Title 50, the civilian agencies do. So as a result of that, we ended up with a patchwork of information security protection programs. And you've probably seen one of the key indicators of that problem, the FOUOs, SBUs, SSIs, IOUs, OUOs, CSIs, and all of the other TLAs, which is three-letter acronyms, which is an acronym that refers to other three-letter acronyms and is itself a three-letter acronym. So as you can see, the government loves its alphabet soup, but the CUI program is here to help address that. So one of the big issues that we currently faced was not only just a mess of these acronyms telling employees to protect, but that they were agency-specific. So when you shared that information with another agency or non-federal environment, they didn't know what they were receiving. So if it was marked SSI at your agency, but you shared it with the Department of Agriculture, their SSI program might be different, or it might not even be a program there. So they didn't know what to do with the received material. Also, when the information was shared under, say, DoD's FOUO program, DoD has policy and regulations and sanctions for failure to comply with their FOUO program. But normally those were failed to be reflected in information security sharing agreements with other agencies. So if they shared that information, which most of these agencies do, the recipient might receive FOUO information but would accidentally publicly release it or store it improperly. And there's really no good way to punish them because it was always hard to prove one, that there's an information sharing agreement on the books, and two, that the employee was trained to that existing information sharing agreement. So it was hard to find and then prove training to. And if anyone's ever tried to punish an employee for sharing either classified or unclassified information, identifying that they knew what they were supposed to do and signed on that they knew how to protect is one of the first steps to punishing them for not protecting it. So it's a very important part of the CUI program was to set out a baseline for how to protect information that would bridge those gaps. Another one of the large issues that we currently faced, not only were we not protecting certain information well and seeing it shared with the wrong people, we were overprotecting a lot of information and not sharing it with the right people. Because each agency had their own program, in order to share information, they wanted to make sure that the receiving agency met all of their requirements and met them in the same way they did. So it was a huge impediment to sharing. In fact, the CUI program was started after a Bush memorandum that was written as a result of an analysis on the causes of 9/11. And one of the causes to that was not just the sharing of classified material to the appropriate agencies, but the roadblocks in place in the way of sharing unclassified information between agencies. There were massive time delays and information sharing agreement issues with sharing that unclassified information that could have helped develop a better picture at the intelligence communities. As a result of that analysis, that memorandum, and some white papers, the CUI program was born. It's information security reform. It's based off of current practices. It protects information that was already required to be protected. What it does is it standardizes and sets out a baseline. It's a framework that agencies can use to apply security requirements to their information and feel safe in sharing in that CUI environment to put the emphasis on sharing to authorized users and protecting from unauthorized users. So it's meant to address both of those concerns that we saw in the existing program for CUI, for information security. Now, the main goals of CUI is that it's standardized, shared, and of course unfunded. I'm joking there. I usually get a laugh, come on. We all get unfunded mandates. But it's actually, there's a reason that CUI isn't inherently funded. CUI is a security reform. All of your agencies are already spending money to protect this information. What we're here to do is make sure that you're spending the money well and that it's focusing on the correct information and that we provide a framework to reduce overhead in information sharing agreements both with the agency environment and non-federal environment. So by providing that framework, we can cut down on a lot of the redundant work that's done every time information is shared and rather rely on a current and existing practice as established by the CUI program to help get that information being shared where it's supposed to be and understanding that it won't be shared with who it's not supposed to be. So the 32 CFR 2002, our implementing directive, is really the key part of the CUI program. It tells the executive branch the scope of the CUI program, what to protect and how to protect it. It was effective November 14th, 2016, and it began the phased implementation timeline that we'll be talking about shortly. It is an entire information security program, and it brings all of those roles and responsibilities back under one office. Every agency has a chief information officer, a physical security officer, privacy lawyers, oversight lawyers, and all the different offices that help come together to create information security program. But over the past few years, we've seen those offices kind of focus on their own lane, and they rarely come together to create a whole picture of information security. And the 32 CFR Part 2002 brings all those responsibilities for information security back under one roof. It doesn't require a reorganization of your agency, but it does require much better teamwork between those disparate offices to make sure that the whole picture is always looked at, from physical security and destruction to the information security side to the legal side of deciding what is and is not CUI and the interpretation of existing laws, regulations, and government-wide policies. So it's a very important cultural shift in that sense. And that's why I come back to, it's unfunded because these agencies, these departments already exist at your agency. They're already working on these programs. What we're doing is trying to get them to work together and work more efficiently. It's a redirection of existing funds. So I said the 32 CFR Part 2002 outlines the scope of the CUI program. And it does, because it references what we call the CUI Registry, which is the scope. For the first time in the government, as an executive branch, we've decided to define what we mean by controlled unclassified information. What should we protect, and why should we protect it? And that's information that requires protection as a result of a law, regulation, or government-wide policy. And that was the task that we were given to find out, okay, so what is required for protection? So there were kind of two ways to go about that. One was to try to read every existing law, regulation, and government-wide policy, which the last time the Harvard Law Journal tried to figure out how many they gave up after 1 million. So that was one approach. We didn't take that approach. We did the other approach that most agencies do when they're given a near unsolvable question by OMB. We did a data call to the other agencies and asked them, what do you currently protect and why? So we asked the stakeholders, what are you protecting? Why are you protecting it? And please send your submissions back to ISOO. We received 2,200 submissions, and as a result, made a lot of lawyers very happy for a short period of time as they got to pore over all of them. We deconflicted, we bounced those off of each other. We looked at them to make sure that they in fact were requirements for information to be protected, and we created the CUI Registry. It's a tool, it's a database, it's a taxonomy of the CUI program. It's a listing of all existing laws, regulations, and government-wide policies that require information to be protected. It, in and of itself, was a huge task and a huge accomplishment for the government. There was no one-stop shop for this before, and there now exists this listing online. It's a live database that anyone can access. It's actually been online for a few years now. It sorted those 2,200 different submissions for information protection and types of information into 23 categories of its taxonomy. It allows for proper marking, and it links directly to the law, regulation, and government-wide policies and/or citations that support that category. So you can actually get straight from our category names like privacy to the A130 and other supporting documents for privacy law. Again, it's kind of the first lift, and it's the scope of the CUI program. For those of you with a classified background, you probably know about security classification guides. This is about as close as we get in the CUI world to that. It tells you what can be controlled. It doesn't have OCAs, it's not the classified program, it's very different, but it is similar in that sense as it says, these are CUI. Again, it's a living document. It's based off of laws, regulations, and government-wide policy. New ones pass or change or are rescinded all the time, so it does get updated. It's fueled by information from our office, proactively looking for new laws that affect information, as well as, and most primarily by agencies, letting us know when a new information type that their agency handles has a new law or a change about its law, so that we can update the CUI registry. So it does change, it does grow. It's not a static database, which is one of the reasons why it's live. It's also live because it addressed an important question, and it addressed a question that the public had. What does the government protect and why? Those answers were different at every agency. Now they actually have a way that they can answer that question. Oh, they protect it, not just because they wanted to in this particular instance, but because there's a law, regulation, or government-wide policy telling them to do so. Another document that came out of our office, and rarely came out of NIST's office with joint work from our office, was the SP 800-171. So CUI has the requirement for the technical environment of the moderate confidentiality impact value. One of the important parts of CUI is that it's shared, and it's shared not only with executive branch agencies, but non-federal entities. It spends a lot of its time on federal information systems, but some of its time on non-federal information systems. So to answer a question almost before it was asked, we jointly published with NIST this SP 800-171, which defines the security requirements to meet what's akin to a moderate confidentiality impact value in a non-federal environment. It takes its policy off the 853, the FIPS 199, and 200. It looks at those lists of security controls and creates security requirements that the contractor environment must follow in order to raise their systems to that level. So some systems were concerned about the confidentiality, integrity, and availability. Those are our federal systems. Those are the systems operated on behalf of the federal government. We're concerned about all aspects of that system. those still have to meet all of the requirements that the government imposes from the FIPS 199, 200, 853. It's a federal information system just operated by a contractor. But there's also those systems that contractors use that aren't federal information systems, that aren't operated on behalf of, but still process some amounts of CUI. And that's where the 800-171 would apply. We're not concerned about integrity and availability so much, but only in the ways that they affect confidentiality. And that's where the 800-171 outlines how to bring a non-federal information system up to that level. It weeds out those uniquely government controls, those CUP and COG requirements that we would require of our systems that we wouldn't require of another system, and focuses on the confidentiality of that information. Now, some integrity controls are still included because they're necessary for the confidentiality, but only those that are tied to confidentiality are included. If the government's concerned about integrity and availability, really what they're purchasing is they're purchasing the system itself, and in which case it should be a federal information system. So it addresses a gap that had long been treated, either ignored or treated very disparately by different agencies. Some required it to meet all federal information system requirements, and others didn't really address it. So that's where the 800-171 comes in and fills in that lack of standardization. Now, the 800-171 is required by use in our 32 CFR, Part 2002, and it should be used as agencies begin to implement the CUI program to communicate standards to non-federal environment. Our agency at ISOO and CUI still has a lot of work to do on CUI. It's your new program, but it's our new program too. We have products that we're working on, like training, which I'll talk about shortly. But one of our biggest projects over the next year is to establish a new FAR and supporting clauses to address the contracting environment and how to communicate the requirements of the CUI program in a standardized fashion to industry. By doing this, we'll be able to take advantage of, when industries meet the CUI program, we can take advantage of that reciprocity. As they meet the CUI program for DHS, they'll meet the CUI program for DOD and all the other agencies because it's that standardized baseline. And we want to make sure that we communicate that properly through our FAR. We'll be addressing issues such as oversight of CUI in the non-federal environment, liability, subcontracting, timelines, reporting, and of course all of the information security requirements in the 32 CFR 2002. So it's a large task. It's a task that we're kind of excited to be taking here at our office. We do ask for help from both industry and agencies. We're going to lean on your experiences and your knowledge to help develop this FAR. Of course, you'll be coordinated through the regular FAR process and comments, but if you'd like to offer thoughts, assistance, or help, or anything based off of experience of recent information security FARs or clauses that you've put out, please let us know, because we're helping to develop a program that works for everyone, and then to do so, we need everyone's input. So here's a slide we'll probably spend some of the most time on. It's the what do we have to do and when do we have to do it slide. It's probably the most helpful. It's an attachment to an ISOO notice for 2016 for the implementation of the CUI program. It was released at the same day as our rule. And it outlines what you should do and in what order you should do it. Now, the time frames here, to put lightly, are optimistic. When you ask most agencies, how long will it take to publish a policy, they say, well, if we've already written it and we're pretty good on it and we've already kind of internally coordinated it, if we put it up for interagency review to be published, it takes about a year. And that's after most of the legwork is done. So we know we were kind of tied to the 180-day time frame. It is an optimistic assessment of all of your capabilities. You should be proud that people think you can do it that quickly. But we understand that that's a really hard time frame to meet, and we don't want you to rush through a policy that does not implement the CUI program well at your agency just to meet a timeline. So if you look at that ISOO notice of 2016, and you flip to the last page, which is the second page, to the last sentence, it specifically states that at any point where you're having trouble meeting a timeline, during your reporting to ISOO, just let us know where you are and when you think you'll be done. We're not really in the business of approving it. We're just going to look at it, kind of do a reality check on it just to make sure it makes sense, and then we're going to move on. Agencies move at different paces. We want to see forward progress. What we don't want to see is bad forward progress, something that's too quick and poorly done. We'd much rather see a measured approach to the implementation of CUI. So if you come back and say it takes a couple of years for your interagency to review, you're not quite sure where you are, so it's going to take longer to write the policy, just let us know on your reporting to us, which will be in May. And we'll cover that a little bit more later. Obviously, if you come back and say it's going to take us 10 years to write the CUI policy and we're not planning on working on it now, we'll have more follow-up questions. But again, we're not really in the place of approving it per se, as just looking at it to make sure it makes sense. And then if there are situations where we think we can help, either by pointing you to some existing policies that people have written, or providing education and awareness that'll get you moving along, that's where we can focus our efforts on those agencies that need that assistance. The next two, training and physical safeguarding, are actually based off of policy. And the reason that is because you can't really start most of your training program or most of your physical security safeguarding program until you've made important decisions about how your agency is going to implement CUI. So those are dependent. So if you request an extension to your policy, we're kind of going to assume that it'll be an extension for both of those programs. Now, training is actually kind of like a super category. There's different types of training that you're going to have to do for CUI. The first that actually shouldn't be pushed back, the first that it should occur at every agency, is sometime around the end of this year or beginning of next year, you should develop and publish agency-wide training on the CUI program. It should cover some of the basics of the CUI program and address questions your agency is going to have, like when will we implement? You should tell them while the agency is implementing, they should follow existing current practices. Don't jump ahead and start using the CUI program before your agency has a policy that supports it. We don't want individual employees writing CUI on a document if your agency hasn't implemented CUI yet. So you're going to have to both put out kind of where your agency is and where it's going and where they should take further direction from, but also kind of the basics of CUI. The reason that we want to put the basics of CUI out and what it looks like and how it's marked is because at around that 1.5 to 2 year mark, some agencies will be fully implemented, or at least very close. So they'll begin sharing CUI. So we have to make sure that the other workforces at agencies are prepared to receive it and understand that they're going to treat it under their existing information security program and existing policies. Once you've implemented, there'll be initial training for all employees. They'll have to be trained on CUI. CUI touches pretty much everyone in the government. PII is CUI, so everyone gets that training, everyone gets CUI training. The next training is the refresher training. We only require it every 2 years, but just about every agency we've gone and spoken to about their training and their plans has decided that they're going to do it yearly. They're going to tie it into their cybersecurity awareness training or their existing privacy training and kind of bring together those trainings into not necessarily one training, but maybe a training with different modules in it to address cybersecurity, information security, privacy requirements. But that's most solutions. And then the last type of training is super user training, or the training for individuals who use particular types of CUI specified, something we'll talk about shortly. Law enforcement information, legal information. These are trainings that are usually already occurring. It might be part of their job training for how they become a law enforcement officer. They go over how to protect evidence, how to protect investigative material. Lawyers all get training on who should have access to their casework and how to protect existing casework. So people are already getting this training usually to some extent. Privacy lawyers clearly, and privacy office individuals clearly get training on privacy information. So most of these trainings exist. The focus on the CUI portion is to modify them, to build them in, to include them in that scope of CUI, and to rope them in. And the next kind of part of that super user training is individuals who are going to be implementing your CUI program. You're going to have to train them. How do you train your managers to oversee whatever responsibilities you give them for CUI? How are you going to train your contracting officers to really start to understand when CUI should be included in the contracting process, if they're purchasing systems or if their contract is going to include the NIST 800-171? Who do they go to ask that question and answer that question? Do you want to point them to CUI, to CIO or a CUI office? they're going to have to be trained on that kind of awareness. Again, a lot of this training already exists, and it's already being done. It's being roped into one house and being done for its express purpose. So while it might add some training time to your workforce, really it's going to replace a significant amount as much as it adds, and kind of simplify that training. Another advantage is under the CUI program, employees that you hire from other agencies will have already been trained. It's the CUI program. There'll be minor differences at each agency that you get to make as choices in your policy. But the people coming to your workforce won't have a brand new policy with completely new requirements. They'll already know about the marking. They'll already know about the basic protection requirements. So there'll be some good changes in that effect. Physical safeguarding is dependent on policy because our 32 CFR Part 2002, our implementing directive, was rather broad about what we required in the physical security environment. And it was intentionally so. Agencies were already doing a good job of protecting information from physically walking outside of its doors. It's not where we were losing a lot of information. A lot of other coexisting programs in the government addressed many of the concerns that the CUI program has. Physical security has been stepped up drastically under HSPD 12 programs. Many agencies have adopted, not only have they adopted PIV or CAC access to computers, but they're also frequently using those for access to different rooms and suites, creating in a sense what the CUI program requires, which is a controlled environment. And the next big, and I say big, but it's pretty easy, the next requirement for CUI in the physical world is a locking barrier. It's your locking file cabinet, locking overhead drawer, a locking office. These are all ways to meet the requirement. It's how PII was currently stored. Again, much of the CUI program is based off of existing practices. It's why we don't really consider too much of new expenditures, more of relying on older expenditures. Now, if your other information security programs had gone a little bit dusty and perhaps you didn't have places or desks with locking drawers, that'll be something you'll have to address, but it's something that should have been working now and will definitely have to be working in the future. The role of your policy and the training will be to define what a controlled environment is in your agency. And it really needs to meet two requirements. One, that individuals who are around open storage or around CUI that they can gain access to have a lawful government purpose to gain access to that information. And two, that employees know when they are and are not in a controlled area that permits the storage of CUI. So if your agency would like to define a certain type of tumbler lock with a certain number of pins, they can internally to the agency decide what that looks like. You can require signs posted, you can require PIV access, you can go back to an old key control system and require escorting. There's a lot of existing physical security policy that agencies have. That is why the physical security part is really dependent on policy decisions the agency makes. But we do consider this to be a rather low lift for the majority of agencies and the majority of their offices. One thing I always like to caution or note on that is sometimes the policy office, especially in this area of physical security, has an overly optimistic view of what is currently being practiced by their agency. I always like to point to kind of two policies that they have. One is their escorting policy. Almost every agency I've been to has a great one written down. It has a limit on how many people you can escort, how long you can escort them for, who needs to be escorted, and what areas require escorting. But in practice, the practice has deteriorated at most agencies we visit. I always like to say that an escort policy lasts about 4 weeks. The first week they follow the policy to the letter and they escort the individual everywhere. The second week they escort them mostly, but they start letting people take bathroom breaks unescorted. The third week, they let them in and they overlook most of them. They themselves might take a break and come back and check on the room afterwards. And the fourth week, they prop the door open for them. And that's about how long they last. And the reason I tell you this is because your policies might be great, but your practices might be lagging behind the policy. It's also very similar in telework for there to be a clause in your telework agreement that says your boss is allowed to, unannounced, drop by your area of telework while you're teleworking to check on your physical security. I've yet to meet anyone who has ever had that happen, and I've met a lot of teleworkers. It's a great policy, it's a great procedure. No one practices it. No boss wants to go to their employee's home while they're teleworking on a surprise visit. It's rarely ever done. So even though the policy looks great, in practice it's not supporting what it's intended to support. So that's really what I caution on the physical security side is to check that. And we'll talk about how to check that shortly. Under systems, which is kind of our next drop down, not dependent on policy, because for the systems we're really asking you to do two things. And the first phase is, what systems do we have and how are they currently configured? And the second phase is, do they process CUI? If so, how do we get them up to the CUI standard? And how long do we plan for that to take? So we're literally, by that year mark, looking for a plan, not a resolution, not everything fixed and updated, but a plan for how you're going to update and modify your systems. So the first step, the assessment in the 180 days to be reported by our May timeframe is how many systems do we have, how are they currently configured? Some agencies can respond to that question in about a day because it's required for FSMA reporting currently. How many systems do you have, how are they configured as a FSMA reporting requirement? But CUI offices are new. Not everyone's prepared to get that answer back immediately. So we give you 180 days to really get your CUI office established, understand not only who the CIO is, but what part of the CIO keeps this information. Start understanding who to ask for it, how to get it, and how to be involved in that process of FSMA determination for systems. Once you have that information, you have to ask the next question, which is, do these systems process CUI? And if so, do they meet the requirements for that CUI? If it's CUI basic, that's moderate confidentiality impact value for FSMA. And if it's CUI specified, you have to check to see if there are controls listed. For instance, PII has a non-tailorable control of multi-factor authentication for remote access. So if PII is being processed on the system, it not only has to meet moderate, but you have to make sure that you didn't tailor out the required control. Once that's done, you just have to provide a plan to update those systems. And good practice security wins the day here. FSMA reviews happen about every 4 years. Systems come online and offline. So prioritize your response. Where is the bulk of your CUI? Some is more important, some is slightly less important. Prioritize that way. Really what we think should be, would work well at most agencies, is find out those systems that are sunsetting that don't have as much CUI on them and move forward without updating them. If they're sunsetting during the scope of your implementation, don't spend a whole bunch of money updating a system that's going to go offline in 2 years. Spend that money on those new systems. Prioritize the new systems. If you address information security from the ground up in your purchasing and contracting for systems and contracting support, it's usually significantly less expensive to approach before you purchase a system rather than tacking security on afterwards. Not only is it usually less expensive, it's usually significantly more effective as well. You find yourself not having to tailor out as many controls due to capabilities of your system. Rather, you've purchased a system that is properly secure. So move that to the top of your priority, and then line up the rest in whatever way your agency sees fit, by quantity of CUI, by sensitivity of CUI, by ability or renegotiation of contracts. If they're coming up for review, that's a good time to put that, bake those CUI requirements in. Or if they're up for their FSMA review, that's a good time to kind of do that audit, figure out how that system's doing, and adding those CUI requirements to the steps of the FSMA review that require updating of the systems afterwards. And last is self-inspection, and this is one I was nodding to earlier when I said a lot of people have policies or procedures that have kind of grown dusty. Part of CUI is going to require your agency to do self-inspection. We're a small oversight office. You've met Mark, probably, and you've definitely met me. So you've met the whole oversight office, because it's both of us. So we're going to rely extensively on the self-inspection programs of your agencies. And that's where you're going to determine, does your policy and training actually affect practice? Are we actually implementing our CUI program effectively? We'll see that at around the 2-year mark, because you can't self-inspect a program that hasn't really started yet. It's kind of one of the last things, but it's something you should always be planning for. And this is, when we visit agencies, something we found that most agencies, they'll do physical security inspections in accordance with safety of individuals. They do CIO inspections according to FSMA. but rarely do they look at the entirety of an information security program outside of the classified world in one go. So this is kind of a new practice that they'll have to get ready for. This practice will also help support and probably be driven by your self-reporting to ISOO every year. So for about a year, for a couple of years, we'll be getting in touch about every 6 months and requiring reporting on the status, essentially every one of these timelines you see here, every 180 days. But for the foreseeable future, we'll also require annual reporting. And one of the best ways to get the numbers for your annual report is to rely on a good self-inspection and self-reporting at your agency to help feed those data calls by our office. Some additional concerns, some questions we get from a lot of agencies. What should we do? How should we do this? Step one, you got to assign a senior agency official and project manager. If you don't have someone responsible for the CUI program and someone to help them implement it at the very least, it's very hard to get a program off the ground because no one's responsible for its success or failure. Second, and what I would tell those two individuals if we had a senior agency official and program manager here, if they asked what the first thing they should do was, it's to get an establishment of a working group or panel or whatever your agency calls, getting individuals from all of the other stakeholders and offices assigned the responsibility of assisting you with the implementation of your CUI program. No one office I've met yet is prepared to implement the CUI program by themselves. Whether it's the CIO office, the physical security, the privacy office, or the records office, whichever office your agency decides to put the CUI program into, they're going to need the help from all of those other agencies, all those other offices, and all of your mission areas. If you write policy without consulting your mission areas and how it's going to affect them, if it critically affects them, they'll non-concur every time. So it usually helps to have them involved in the policy making process as opposed to just the policy approving process to help that all move along quickly. Next thing to address is incident management. It kind of goes hand in hand with self-inspection. It helps inform on that program. It also ties into training, of course. What should we train to? Well, we should train to things that are causing us to lose CUI or have CUI incidents. So you should modify training to address that. Everyone already has some type of incident reporting, definitely for privacy, which has very strict requirements, but mostly also for other types of information that goes missing. The key here is to look at what types of incident reporting do we have at our agency and make sure that it's bounced off the CUI program. Add yourself into that flow sheet or checklist that those call centers or databases use to make sure the question is asked, was CUI involved? Was CUI leaked, stolen? Was it possibly compromised? Did someone take pictures of it or gain access to it who shouldn't have? Most people have physical security reporting when an office gets broken into. The question should be asked, was there open storage of CUI in there? Most people have a reporting or a way to report when they lose a laptop with CUI on it. When they lose privacy information, that is CUI. Were there other types involved in the loss? Even if they are reporting a classified incident and classified material goes missing, which of course they're required to report, does the question get asked, was there also CUI in the report or was it just classified? So it's less of establishing a brand new way to report and more of tying CUI into existing reporting mechanisms. And then one of the big changes, and again, information security practices rule the day, risk management and prioritizing, updating existing contracts and agreements to reflect the CUI program and its requirements. One of the primary intents of the CUI program was to provide that framework to help agencies share information more easily, to inspire that trust between the intelligence community and the defense community and the NT50s and civilian agency communities, that we have one information security program and that it works the same or very similar everywhere you go to help you share that information. So address your legacy contracts and agreements to both federals and non-federals to see, are we requiring things that we don't need to require anymore? Are we pushing agency-specific policy that really applies to us and shouldn't apply to them because they, as the receivers, have a better understanding of how to protect that material internal to their agency once they receive it? So limit those. Revisit them and make sure that they're serving the ideas of standardization and sharing of information to the appropriate individuals, the authorized holders. So that's kind of the first half of our briefing. We went over most of our documents. We covered implementation, our approach to the contractor environment. So now we're going to kind of dive into what do we mean by safeguarding, what do we mean by protect. And to answer that question, we have to talk about the two different types of CUI. Because there is a division in CUI. We treat some information a little bit differently. As I spoke about earlier, CUI is information that's required to be protected by law, regulation, and government-wide policy. It's where the law, the regulation, and government-wide policy defined an information type and said protect. If that's all it said, then it's CUI basic. If the law identified information, said protect this, we protect it at the CUI basic level. But some laws, regulations, and government-wide policy is considered something else. They said, here's an information type, protect it, and they kind of fall into two different categories. They either added a specific safeguarding control, like the example with privacy information requires non-tailorable multi-factor authentication for remote access. It specifically states that as a requirement. That's CUI specified. And then the other kind of type of CUI specified is where it expressly stated a particular type of dissemination. It really defined what we mean by lawful government purpose by saying you have to go through or meet this requirement. So an example would be like grand jury information requires the Attorney General or designated individual's approval before disseminating. Those are CUI specified. It's CUI, but there's something specific in the law, regulation, or government-wide policy that you have to follow in order to protect that information. So it's an important distinction from basic. CUI basic falls under all of the policies that we lay out in the 32 CFR Part 2002. It's protected as CUI. CUI specified follows all of those same policies unless the law expressly says something different. So it's only different where it's expressly different. Other than that, it defaults to the protection of CUI basic and regular CUI. And it's different only where it says it's different under the specified law. Now, the majority of those currently are dissemination controls or limits on the dissemination. But as we imagine with the framework of CUI, new laws and old and existing laws will probably be modified more to address the specific information types that they are. And if there are important controls that apply to that information type, they may be added. So it's important to understand kind of some of where the CUI program is going, especially in the digital environment, with regards to the possibility of new controls on CUI specified. So one of the intents of the CUI program was to limit the effect of internal agency decisions. We outlined the scope, we outlined the safeguarding, we outlined the baseline in the 32 CFR Part 2002. We say this is what you need to protect the information. We encourage agencies then to make agency-specific determinations, like increasing physical security requirements in certain areas, protecting certain systems more or less, but the information itself has this requirement of protection. And when sharing, it should default back to that. And if it's going to have to go higher, then the receiving agency should make that determination, because it's their system, it's their location now. So we do stress that one of the benefits of the program is the ability to rely on that framework, to share that information more easily between agencies, because you can rely on the CUI program and its baseline is to protect it. At its heart, we're an information security program reform. So the purpose of CUI is to prevent unauthorized sharing or receipt of CUI information. And then its corollary purpose, because the whole reason the government keeps information is to make sure that the right people have it, is to make sure that authorized holders get access to that information easily and efficiently without jeopardizing the first purpose, which is making sure that unauthorized holders don't. So remember, information security isn't about keeping the information away from everyone, it's making sure the right people have it. That's where the standardization and the impetus on sharing comes from. So our physical security requirement really is a controlled area with a lockable barrier. We leave a lot to be defined by your agency. Again, you can go the electronic route and have PIV and CAC access or use Linnell systems to gain access to a room. You can use locking doors and implement key control like the good old days of physical security. You can have a security guard or an executive assistant that observes who comes in and understands who has to be escorted. on the flip side, you can have, for the locking barrier, you can use safes, you can use locking file cabinets, overhead compartments. Just make sure that everyone has a key, has a lawful government purpose to receive that information. So if you're one of those people that bought those cubes that all of the keys to their overhead bins are all one key, you'll have to revisit that. But generally a pretty low lift for physical security. Now the reason it was a low lift for physical security, like I stated earlier, was because most of our information wasn't walking out the front door of agencies. Most of it was taking the electronic path. So we were significantly more explicit about our requirements for the technical environment, and that's the moderate confidentiality impact value at a minimum for every system that processes CUI. FIPS 199, FIPS 200, FSMA 853 list out the controls and the procedures for getting a system up to the moderate confidentiality baseline, but this is the security requirement for CUI. Now, no good information security program can work without a good marking or a good marking program or scheme. If you don't know what information to protect, you can't protect that information well. And the marking has to communicate this type of information should be protected at this level. So we've implemented the CUI marking policy. We have a marking guide online. I'll talk about it a little bit more later. But at its base, we've standardized how CUI should be marked. It has a banner. It will be either controlled or the initialism CUI at the top. We do include best practice marking, where you're allowed to mark the document at the bottom center as well. It's an encouraged practice reflected in the classified environment. Portion marking is also optional in the unclassified environment. It's required in the classified environment, but it is in many cases very helpful to identify not just that an entire document's controlled at the CUI level, but what particular pieces of information in it are CUI. Now, the document we saw before has the banner for CUI, the protection for CUI of a CUI basic document. If the document's specified, you have to include the next step of the banner, which is the category or control marking. Now, you can include those in CUI basic, but it's required for specified. And what that is identifying that the document is not only controlled, but it's controlled with this particular type of specified information. As I mentioned earlier, specified material has a slightly different protection, whether it's a dissemination limitation or it's an actual physical or technical safeguarding requirement. It has to be treated differently. And if you're going to treat information differently or protect it slightly differently, you have to mark it as such so that the users, the receivers, the authorized holders understand that that information requires not only different treatment, but what kind, which is why we include the actual category for specified in there. And then the last part of the banner line, which is optional, is the use of dissemination controls. We have a dissemination list on our registry. We're in control of not only the names and how they're presented, but the definitions of those dissemination controls. They must be authorized in agency policy to be used, and they should restrict the distribution of that document in furtherance of its lawful government purpose. So as you can see at the top here, you have the CUI basic marking, that initialism CUI. You have 2 forward slashes and then an SP dash that lets the user know it's a specified document. Where it says specified is where you'd get the actual category marking. So the 23 categories and subcategories have their own unique markings in the registry. You can find them online. We have a printout that people can use for a shorthand. And that's where you'd see that usually 4-letter initialism for that category. And then the // and then the dissemination control. So a little bit more about specified. So how do I know what CUI is specified? Well, we already did the work. We already read the laws, the regulations, and the government-wide policies. We looked at the controls and citations. We listed them all in the registry. And under the categories that you can click on through our registry, we tell you that this citation is or is not specified, and that the information that it covers qualifies or does not qualify for specified protections. And that right there, circled in red, we answer the question basic or specified with the answer. If it is specified, it has to be marked in the banner. It will be marked in portion marking if you're going the portion marking route as well for the unclassified environment. And again, it has that SP dash, and that lets the user know that it's specified without memorizing the registry and understanding and remembering which 4-letter acronyms are specified. That SP dash calls that out to their attention for additional protection. a rather different protection. Our policy also addresses bulk or alternative marking. We don't actually require each and every single piece of CUI to be marked. We require it to be marked in aggregate, and then if it's separated from that aggregate. So if you have a database that's all CUI and it's all PDFs, you can mark the database. It helps if you know what types of CUI are included, and you're going to have to train the users of that database and make them aware that CUI is attained there. You can do that through a splash screen, or a system access form, or system access request, or a banner marking that tells them you're accessing a database that has these types of CUI, and you have to make sure that they're trained on what to do when they remove information from that database, when they print it off or take it out, that they have to mark it appropriately when it's separated. This also applies to marking filing rooms or boxes of information. That's a current practice in the government, to mark information that way and get more granular when you need to after you take the information out. But it's important to make sure that if you do go this alternative or bulk marking route, that you make sure that the people who may end up removing the information from that database or that box or filing room understand what types are there and how it should be treated and marked when being removed. We published our marking handbook. We're about to see our second revision to it shortly to address markings in emails and a couple of other marking schemes. No real changes to the existing, just additional guidance for how to mark in different environments. It's already on our website. You can download it from there and print it off, but it goes in depth into how CUI can and should be marked. We also allow for the use of our optional forms, our cover sheets. So one of the results of that initial data call to the agencies of what they protect was we received a lot of different cover sheets, all addressing the protection of CUI. Some of them were disturbingly similar to Special Access Program cover sheets and other classified cover sheets. So we wanted to standardize that practice, but we didn't actually want to require cover sheets. So we provided an optional form. We're allowing for agencies, we're giving them a tool to use to have cover sheets, ensuring that when cover sheets are used that they're standardized and they look the same and are used the same, but we don't actually require their use. They're more of a tool for, say you have evidence or material. You can't actually mark the evidence. Judges frown on tampering with it. But a cover sheet is an excellent solution to documents that can't actually themselves be marked. Two of the documents are fillable PDFs. You can get them either off of our website or through GSA. They allow for, in the top, including the categories or subcategories that the cover sheet is protecting. And in the bottom, they allow you to add the warning paragraph or statements that some types of CUI specified require. The cover sheets come in green. They can be printed out black and white. We encourage you to keep them in color, as that's the best way to really understand what it is you've covered up, and definitely encourage you to keep them in color in the classified environment because CUI is unclassified as part of its name. We do allow for a waiver of marking legacy information. It has to be proactively done by your agency. The exact procedures for how you do it can be outlined in your policies. Essentially, you can waive the marking of legacy material that your agency holds. However, if that material is reused or shared, it must be remarked. Legacy markings must be removed, and the new CUI markings must be added if that information does qualify for the CUI program. It's not always a trade one-for-one. Not everything FOUO will be CUI. That's part of the reason that there is CUI. While you can waive this information, again, it's limited by reuse or sharing. We also intended the alternative or bulk marking system to help alleviate some of this burden. It's not too hard to mark an entire database with a banner or a splash screen, and then it's considered marked, and then provide guidance when you do remove this FOUO information, remove the FOUO, add CUI if it qualifies, and then share. To go that second route, you actually wouldn't even need to waive the markings because you've marked the material according to the new program. But we did allow for that. That would have been a huge added cost if everyone had to go back into all of their records and remark it. So we did include that waiver process. Another area where the CUI policy was rather specific was in destruction. We found some agencies with very particular destruction methods and others without it. For the most part, everyone was already using the NIST 888 for the media sanitization guidelines. So if you had to wipe your hard drives or you had to wipe a mobile phone or device or anything like that, most agencies use the 888. But the 888 also included recommendations for how to destroy, or a standard to which to destroy paper material. So we reference it for all of our destruction purposes. Again, it's the NIST 888. On the top of this page, top right, you can see a picture of what a lot of agencies were currently using to destroy CUI, and what in fact one shredder company advertised as a CUI-approved shredder. And I don't know if some of you are too far away, but you can actually still read names and socials on that material. It does not meet the NIST requirement of unreadable, indecipherable, and irrecoverable. The lower standard is the standard that we actually require. It's 1 millimeter by 5 millimeter. It's the requirement to destroy most of the classified paper documents as well. Now, we also identified through our working with agencies an existing good practice that is allowed under the NIST 888, but isn't explicitly mentioned. So it makes it a little bit more difficult to continue with an existing practice that we actually very much support. And that's multiple phase destruction. So while a lot of agencies were destroying to that higher standard, they were then frequently protecting that material to some degree, usually by sharing it with a contractor, who would move it off-site and then pulp it in the recycling process. Now, the end result of that material, after it's been shredded and pulped, is unreadable, indecipherable, and irrecoverable. So that is an acceptable means for the destruction of CUI. It's just not explicitly stated in the 888. You'd have to write out that it meets the end result requirement and write out the process. Now, one of our office's other goals for this year is to help with either a revision or modification to the 888 to explicitly and expressly allow that practice to help agencies with that. One of the driving causes for that, not just because it was an existing practice that agencies use, but also it's very difficult to shred that small, or to recycle that smaller shred size. It destroys the fibers too much. It makes it much harder to recycle. And we don't want all of the CUI that's being destroyed in the government to not be as easily recyclable or recyclable well. So it's one of the reasons that we're focused on getting that update or modification to the NIST 888. So that kind of ends our main key requirements in the 32 CFR for safeguarding. So we'll go over kind of what's going to happen moving forward. So we're going to continue providing briefings, both in this forum as well as in the teleconference or WebEx online forum. Our next ones are scheduled for February 14th and 22nd. Anyone and everyone is invited to attend. We'll try to make sure that we have enough lines for everyone who are SVPs. But we'll be providing kind of an overview of what we've gone over today, what's changed, what's happening, the status of our FAR, any new things that have come out, changes or additions to marking books or the registry. It's just our way of putting out information to both agencies and industry about where the CUI program is now and where it's heading. And we're going to try to continue with that quarterly. Some requests for you. If you don't have a designated senior agency official or program manager at your agency, please designate one and send one to Mark or I. It helps us build a line of communication with your agency and understand and assist you with the development of your CUI program. Begin your implementation activities as talked about in the implementation guideline. Focus more on the requirements and the order of them rather than the timelines associated with them. They're excellent goals. But again, somewhat unrealistic for some agencies. In our report that we're going to send you in May, please identify cognizant offices or dependent programs. If you rely on another agency for the destruction of your information, or you use their training program for information security practices, or if you're an agency that has another agency that uses those programs of yours, please identify them in your first report to our office in May so that we can understand. Some agencies may be entirely following under another agency for their protection. We don't want to double up on reporting or anything like that, and make sure that that's managed appropriately. And And last, we'll be contacting you again shortly in May 2017 with our reporting on implementation. We're coming up with, we have a working group through our advisory council deciding the exact layout and questions asked in that form, but it's just about in its final state. So we'll be receiving those shortly, and then again, annual reporting going forward. For all the agencies on the Chief Financial Officers Council, it'll also start in a year or two seeing us, Mark and I, come out for our formal inspections. Where we'll review all the elements of the CUI program and provide guidance, tell you how you're doing and how you could do better, identify best practices that we can share with other agencies, and that'll happen on a recurring 4-year schedule for the Chief Financial Officers Council. For everyone else, we'll be including kind of ad hoc in a way, inspections to the other agencies that either request it or identified as needing more assistance in establishing or overseeing their CUI program.